Alrighty, and Miss Magda, I'll just jump in once we have a series of questions, and I'll just let you know what's coming up in the chat. Thank you.
All righty, let's start. I'm going to introduce myself briefly. I know there's 70 of us here, so maybe introduction around the table is not the best idea. We'll take half of the time we have for this, but my name is Magdalena Koczynski. I have been with Family Justice Center for almost 10 years now. January will be the 10th anniversary of me working with the center. I've previously practiced immigration law, and now I specialize with family law and mostly domestic violence cases. So let's begin. Jose, by the way, I can hear my voice in your office. If we could just limit the echo, that would be awesome.
Okay, sound should be down, the echo should be reduced, and I'll jump.
All righty, let's start. So as you probably all heard the word divorce, we've heard it, people do it all the time. Divorce is by law called dissolution of marriage or dissolution of legal partnership. The process is the same. We use the same forms for both. It's a legal process that ends domestic violence, domestic partnership, or a marriage. After divorce, you can be a single person, you can remarry, and the court will decide all the necessary aspects of your marriage, meaning child custody and visitation, child support, spousal and partner support, property division, whether there's a need a restraining order or not, and attorney's fees. So there's two options to start the divorce. We can move the slides, please. So there's a difference between divorce and a legal separation. A lot of times clients who are not ready to file for divorce, they will choose the option of separation. What it means is you are still legally married, but you are separated. So from the date of separation, you create your separate property. It no longer is community property. Previously, we chose the separation option for insurance purposes. As you may know, a lot of our clients are the beneficiary of the spouse's insurance. Once you terminate the marriage, there's no possibility to be kept on that insurance. So for years, we've had a lot of separations to keep that spouse on the health insurance. Health insurance companies caught up with that tactic we've used. So no longer is the case if you're separated and there's a judgment for separation, keeping the insurance on that spouse is not possible. So sometimes we use to file for separation if the client, let's say, just came from another state and is not a resident of California. Let's move on. I'll get to the residence requirements in a little bit. I would like to explain what annulment is, because we see cases in which the clients come in and believe that there's fraud and somebody married them for a green card, or they're not getting along and they would like to erase the existence of this marriage. So annulment will nullify the marriage, and the court says that this marriage is not legally valid, which means it never happened. What that also means is you're not going to be able to ask for spousal support because you're trying to have the court pronounce that this marriage was never valid. You can use those. Sometimes we have cases in which a client believes that their prior marriage was resolved, and turns out they got married again without the judgment in the prior marriage. We resolve this by asking the court to rectify the situation and provide a divorce judgment in the first marriage so the second marriage becomes legal. What are the bases for annulment? There's many, as you can see, I listed them here: petitioner's age of the time of marriage or domestic partnership, prior existing marriage or domestic partnership, which is something I just mentioned, unsound mind, which is something all of our clients would like to use because everybody coming into our agencies probably thinks the other person is of unsound mind. That is a very hard proof to make. Fraud, force, or physical incapacity are also good ones. In general, courts will examine whether the fraud goes into the procreational aspect of the marriage, meaning this person lied to me. They, in fact, do not want to have children. I married this person to create a family. Please annul this marriage. So those are the cases that mostly will grant an annulment unless you can prove fraud in some other way. Let's move on, please. Any questions so far? Separation, divorce, annulment? No? So putative spouse is the spouse that I've mentioned, is the person who believes that their marriage was entered in good faith. But for example, the other spouse was already married to somebody else. So we come into to courts to determine if their belief that this is a real marriage is genuine or not. Is an apparently valid marriage entered in good faith, but there's some technicalities that may not allow this spouse to be a proper spouse. So first we will determine if the marriage was valid, and then we call them a putative spouse, which means she had such a strong and valid belief that in the validity of this marriage that we need to give her a divorce, hence also division of assets and spousal support. Next, please. So common law marriage is something you may hear about, because I always hear about it. I'm Polish. Polish community is convinced that if you live with somebody for 10 years, that will create a bond called marriage, common law marriage. California, unfortunately, does not recognize common law marriage. We cannot create a common law marriage situation in California. But if parties come from another state, let's say like Texas, I think Texas still has common law marriage, and they were able to establish that common law marriage legally in another state, California will recognize that marriage and will provide a divorce for the couples. So cohabitation alone does not create any community aspects. It doesn't create community property. There's really nothing to divide if they're not married. So basically, if let's say a couple buys a home during that common law marriage, which we don't recognize, it becomes a civil action against each other. It's not going to be a divorce, but the civil court will examine if there's any need to reimburse each other and how are the financial situation is playing out with the couple. Next, please. So requirements to file for divorce. You can file for divorce in the county if you or your spouse live in that county for at least 3 months, and in California for 6 months. So let's say we have a client who moved from another county in California. They are now, let's say, in Contra Costa. They would like to file for divorce, but they haven't been here for 3 months. We can file for separation, and once the residency attaches to them, meaning they've been in California for 6 months and then in this specific county for 3 months, they get to amend the separation petition into a divorce. If you do not meet I already said that the residency requirements, we amended later to a divorce. Let's move on, please. I'm not seeing the chat here. Maybe I'll put it up. I have a client that is a low income. Is there any fee waiver? We'll get to fee waivers in a second. So those are the necessary forms that you are required to fill out. How do we get those forms? We can simply go on the court's website and obtain them for free if we have a printer. We can send the client to the law library at the courts and pay a little money for a copy. The two top forms are starting a divorce for couples without children. The FL 105 needs to be added to the divorce with children. There's other forms that will be indicated on the actual petition. So let's say if we're doing custody, the form will inform us, go to FL 311. And it's like a roadmap. And once we follow the roadmap on the actual forms, we will have all the forms we can possibly generate to ask the court for what we need. The good part about California system is that it is designed for people who don't have attorneys to be able to complete a lot of things by themselves. Everything is available for free. There's a facilitator's office in every court. For fee waivers, as we had the questions about that, there's two forms that needs to be filled out. It's FW001 and FW003. Those are the two forms that are required to request a fee waiver. I'll have another slide on fee waivers later on, but let's not forget that every petitioner, every party petitioning the court should come with 3 copies unless it's filed electronically. Come to court, file 3 copies. 2 copies will be returned. 1 is to be kept and 1 is to be served on the other party. Next, please. So service of process is probably the next most important step here, because we go and file something with the courts. We need to provide notice to the other party. They need to know that there's a case against you, show up on this day for the hearing. So we need to serve them with the documents. Who can complete the service? It needs to be a person 18 or older, not a party to this action, which could be a neighbor, a friend, a sheriff for free if there's domestic violence or a fee waiver on file, or you can hire a process server. Proof of the service needs to be filed with the courts, because every hearing starts with the judge checking, did you give notice to the other party? If not, then we need to give you continuance and wait till they're notified. We allow 30 days for response for most filings. So we're starting a divorce, there's a 30-day mark for them to respond. Let's move on. So what if other party refuses service? And the service is probably one of the most questions I'm being asked, because people don't understand why it needs to be done in a personal way. And what if the person refuses? I actually had recently a case in which the client tells me that a person approached the opposing party, and they refuse to take the documents. Well, they don't have to accept them. They don't have to take them and say thank you. All we need to do is drop them in front of them and say, hey, you've been served, service completed, fill out the proof of service, file it with the courts, and continue with the case. Next, please. So what if I cannot find the other party? A lot of times, especially in the domestic violence situations, we have 27 days after receiving the documents before the hearing, the documents needs to be served. Clients drop cases because they show up several times, they couldn't serve the other party, they're hiding under a rock, right? Then you can ask the court for a alternative service. If we move to another slide, we can probably see the other options for alternative service there. Okay, so there's a personal service that we've just discussed that needs to be done by a server, a person 18 or older. There's the service by mail, which they can fill out a little note saying, I acknowledge I've received it. There's a substituted service. There's a service by acknowledge of receipt. There's a service by posting. The most extreme option is to post the documents on the bulletin board in the courts in hopes that this respondent will just happen to be there and passing by, and he will notice that, or she will notice that there's something on the wall with their name on it. So let's not forget that the clients may ask for alternative service if there's several unsuccessful proofs of service. Let's say the sheriff is accommodating the client and they cannot find the person. Then they file those unsuccessful proofs of service with the court. The court sees, yes, we've approached this person several times. They're not opening the door, whatever the reason is. Then the client may request, Your Honor, may I try to serve him somewhere else or in some other way? The courts will examine the facts of the case and decide which one of those alternative options is best. Next, please. So how to respond to a divorce and why, right? You can respond by filing a form FL-120 with the courts. If you don't file a response within 30 days, the other party may ask for something called default. Default basically means that the courts will decide your case without your participation. So the documents you initially receive, if you see on those documents that the opposing party is trying to terminate spousal support, that would be a very good reason to respond and say, no, let's not terminate my spousal support. I would like to receive some spousal support. The court can could end the relationship or make orders about property as well if you're not participating. So let's say that party listed the community home as an asset from the community, but they say, I want 100% of it. If you don't respond, very well, this husband or wife will receive 100% of community assets if there's no response. Next, please. So once the client signs, there's a petition and there's summons. Summons is form FL-110. Summons has something called now standard family law restraining orders. Previously was called ATROS, and a lot of attorneys will use the word ATROS. It's an acronym for automatic restraining orders. which basically means once you sign the summons in your divorce and the opposing party is served with those summons, at that point, those automatic restraining orders apply. And what they do is they freeze the community property assets in a way. You may be able to do things that are in the ordinary course of business, meaning you can pay bills, you can buy groceries, you can do those things. But if you're not a car dealer, you should not be selling cars after being served with a summons, right? If this is not your job to sell cars, you should not be selling community property, cars or other property, or transfer the deeds to your family members, brothers, sisters, or other relatives, right? So this is to freeze and keep the status quo until the courts may examine what's in the community, what do we need to divide, and how should we do that fairly 50-50. Questions about that so far? No. So I gave you here 3 examples of those things that are prohibited with the ATROs, with the standard family law restraining orders. You should not be giving away or hiding money or property. You should not be changing beneficiaries on your health insurance or other life insurance, for example, or take the children out of state. Next, please. Oh, we're lost. Okay, so now we're at the response. We already talked about the default options. Even if the person doesn't respond to the divorce, but they're cooperating with the other party, and let's say they hired a mediator to create a settlement agreement, this client still can enter the divorce, have the agreement placed with their signature, meaning they can still participate without the response filed on with the courts, but they can reach an agreement outside of courts, write it down, file the judgment documents, and still be divorced without appearing. Okay. Once the default is entered, it makes it more difficult for anybody to undig that situation because the court already decided on the case. They saw that this person was properly served. They decided not to participate. So we want to finalize the case and make those orders. And then we see clients a few years after that judgment was entered, and now they're realizing, hey, I don't have any spousal support. Hey, the other party never shared their retirement account, and they took the entire community property home. I received zero money from it. Then attorneys will have to scratch their heads and find a good reason to ask the court to set aside that judgment, which basically means there was fraud or there was some other issues or arguments that we have to convince the courts to put this judgment aside and decide whether this client should be getting any community assets, spousal support, and all those things. Next, please. Parentage. So as you see, a lot of our clients are not married. So we're not divorcing them all, but there's children together and we need to sometimes establish custody. They're asking for child support and they would like to have a roadmap how to parent together. If we have a situation in which we have 2 parents who are not married, first question we ask is there a declaration of paternity signed in the hospital? Declaration of paternity is a document the hospital will provide to the parents to say, I'm the mother, he is the father. The father's name is going on the birth certificate. The voluntary declaration of paternity is being sent to the state. It can be revoked within 60 days if they change their mind. If you file a paternity action without a declaration of paternity, you can do a DNA test, or if you're not sure if you're the parent of this child, you can ask the courts to order DNA testing. Once DNA testing is done, you can the court will make custody and support orders. Okay. You can file three actually forms for that motion: FL 200, FL 210, and FL 105. If you need to waive court fees, it will be again the same 2 forms, FW 001 and FW 003. You can also start a paternity and child support request within a Department of Child Support Services. It's a local agency. I believe that DCSS is probably the best thing after the sliced bread. and they have more tools than any private attorney on the planet. They're like an octopus. They can freeze people's accounts. They can take away fishing licenses for arrears and child support. So not only they will establish child support, they will also collect on it and calculate arrears. So it's a fantastic thing to do, and it's free of charge. So let's say we have clients who just need child support and they don't want to deal with anything else. Like they're not ready to file for DVRO or other stuff, and they just need the support. They can start their case for free with DCSS. There's many attorneys there working for DCSS, calculating those numbers. It's just a numbers games. So that's that. Can we get next, please? So who is a legal parent, right? You may know what it is, but this world is creating so many different layers to parenting that sometimes we get confused. So let's go over a definition. You are the child's birth parent, not a surrogate. So for mothers, you gave birth to this child, right? You and the other parent were married or registered partners when your child was born or conceived. So there's a presumption coming from the marriage. If the child was conceived during the marriage or born several, I think it's like 200 days something after the marriage, we have a presumption that this child is born from this marriage. Hence, if the parties are getting a divorce, we will examine if this child is the child of this marriage or somebody else is the parent. You are the parent when you file the declaration of paternity that we discussed, or the judge determined there's a judgment for paternity after we already did the DNA test, or you agree that you're the parent in court, the court can issue a judgment saying you're the parent of this child. Next, please. So legal parents have rights and responsibilities. A child's legal parent can ask for custody and visitation. Parenting time orders are required to financially support their child. Can be listed on California's birth certificate, and child can inherit and get financial benefits like Social Security benefits, survivor benefits from their legal parents. A child born outside of the U.S. may be able to become a U.S. citizen if one of the legal parents is a U.S. citizen. Those things are changing, as we know. So it comes with a responsibility, and sometimes we hear cases in which the other parent, the parent we talk to doesn't want the other parent present in the child's life. They believe that it's harmful for the child, and I'm being asked a lot of times, like, how do I terminate their rights? Well, if you terminate their rights, you also terminate their responsibilities, which means responsibility to care for this child financially and provide for them. This is your child's right to be taken care of by both parents. So even if there's an agreement between parents to, let's say, I'm not going to ask you for child support for whatever reasons, right? And situation change, they had this agreement, they probably linked this agreement to some other agreements, and I will not ask you for child support if you do XYZ, right? And then things change and that mom or dad needs to file for child support because they are strapped financially. The court will not take parents' agreement into consideration because it's not their right to waive. It is your child's right to be supported by the parent. So even with those agreements present between the parents, the court will go ahead and still issue child support order. Next, please. Here we are, Department of Child Support Services. Again, I provided you with their website, so you can easily start a case online for free. It's just a few buttons away. If your client has some financial information, let's say the other party's pay stubs or W-2 or something to show how much the money they make, you can start your case online, not a problem. Either parent may enroll in services regardless of whether or not the child support order exists. DCSS may help locate the other parent, establish legal paternity. If required, get a court order and enforce it in every state and foreign countries, which is super important because sometimes clients don't even ask for child support thinking, oh, the other parent is in another country, there's not going to be ever a way to enforce it. Yes, there's way. You're working with DCSS. They have very long hands and they can reach people in other countries as well and in other states. So DCSS may also calculate arrears and provide income withholding for support orders. Those arrears basically never die. So years ago, we had a client come in. He was, I believe, 80 something, and the child from this case was 50 something. And there was an outstanding $58,000 child support order arrears from when this adult was a kid still. And they didn't know what to do with it because now child support DCSS was going after this retired person who no longer has any small children, but arrears are still there and the state needs to be paid. Next, please. Guideline child support. So there's two numbers that go into the child support calculation, right? It's a computer system calculation. We put in both parents' income. We put in the timeshare of how much time each parent spends with the children, and we implement mandatory deductions. So mandatory deductions will be if you have mandatory union dues, or you pay for health insurance for the entire family, or some other, there's like some 401k payments we can deduct. So just to get you an idea of how this works, a 50-50 timeshare with similar income on both sides will produce very minimal or zero child support. If you have a parent who has the kids 80% of the time and making significantly less than the other parent, then there's going to be a lot more child support. So a reduction in timeshare has a big effect on child support. Why do I say this? Because it is the first thing a lot of parents learn very quickly. The timeshare either will ruin you financially or not on both sides, because either you have to pay a lot more than you can afford, or you're not going to get enough to be able to survive, right? So there's a lot of arguments and cases trying to get this timeshare to max out for the benefit of specific party. So if it's the payor, he wants to pay less. If it's the payee, he wants to be paid more. Therefore, a lot of times the custody piece is being argued a lot because one parent is convinced that, oh, if I get to have the kids more, I will pay less child support. Or if I get to have the kids more, I'll have enough child support to be able to pay my bills. So sometimes in cases that we settle, if that is such a big deal and we know that parties will never agree unless the child support is on 50-50 timeshare, we will agree to calculate child support on 50-50, but create a separate custody order that fits the family needs, but also satisfies that payor for paying less. So yes, the client is getting a little less money, but at least the client gets to be with the kids and all that. Dissolution cases, can you explain what joinders are? Joinders are situations in which, let's say, you have husband and wife in the case, one petitioned for the divorce and one is the respondent, right? So whoever starts the case is the petitioner, who is responding to the petition is the respondent. And let's say we have a retirement plan, right? We need to join that plan to be party of the action. So the court can tell the plan, hey, divide this retirement for them 50-50, prepare an instrument. Or for example, you have a case in which one property in the marriage is owned by some other people. And half of this property is community property, but the rest is owned by somebody else who the courts doesn't have jurisdiction over. So we join them to the case, right? We file a joinder, ask the case to ask the court to join this person so you can decide full ownership of this house because there's the community property component. Does that explain this? Was that clear? Can somebody nod? Jose, I see you. Okay, next one, please. So request for order. Once you have a case established with the courts, which it would be divorce, restraining order, paternity, you can ask for extra orders. What orders can you ask? Well, it's very easy. Form FL 300 spells it all out. So you can choose, you're trying to modify things, you're trying to terminate things, you're trying to establish things. And you can check the boxes for child support, spousal support, custody, division of assets, attorney's fees, to force the sale of community home, to keep the passports of the children. Whatever it needs to happen to finalize this case, you file a request for order. You make 3 copies, pay a fee of $80. If not, you ask for a fee waiver and wait patiently for the hearing to come up. You need to be sure that the other party is served. Once your hearing comes up, the judge will decide what to do with the issues you have in front of them. Next, please. So, ex parte, the famous ex parte. It's an emergency motion that we basically bypass the line. So as I told you before, the RFO, request for order, we call it RFO, is a longer process to see the judge. It's like, I'm going to request a meeting with the judge to present my case. But a regular RFO will probably make you see a judge in about 2 to 3 months, because you file and you get the hearing scheduled 2-3 months in advance. But sometimes you'll have a true emergency in your hands. Let's say the other party is kidnapping the kids, or they're going to sell the home and just take all the money and take off, right? We ask for this emergency motion. We bypass the line, which means we just don't go to court and file a plain motion. We need to provide a notice, 24-hour notice, to the other party and say, hey, I'm going to be filing this because there's an emergency. You have 24 hours to respond. Sometimes you can tell the courts, I cannot give them notice because a major injury will happen to a child or property if I do give them notice. So I'm doing this for an injunction purposes, to stop something from happening, something very big. It cannot be just, oh, I want to sell the home right now because that's my wish. You really need to establish there's an actual emergency, something's on fire, a child has access to drugs, or they're being abused, or they're about to be kidnapped, right? So we're asking the court for those ex parte orders, meaning without the participation of the other party. We're kind of going behind their back because there's an emergency. We need to justify this emergency first, right? We need to really show that this child is on fire. Please give us orders so we can call for help, right? Or this property is going to be sold if I don't take over and start paying mortgage. So it really needs to be a true emergency. We need to remember about the service of documents prior to filing, because a lot of times, even attorneys with 10, 50, 20 years of experience, they still don't get the rules of ex parte. And mind you, the rules are different in every county. So in Cocoa, you need to provide the actual documents 24 hours before, preferably in person, or longer services through mail. In Solano, you need to call the opposing party and say, hey, I'm going to be filing this. And then you're being served with the judge's decision, basically. So please keep in mind that every county has different requirements, but first of all, start with the emergency. Is it truly an emergency? Do I really need to file an ex parte? Is harm that will happen if I don't so grievous that I need court's attention right now? I feel like we're abusing the ex parte process, especially in custody cases. I know that a lot of things that are happening to our kids are in our minds an emergency, but it's not always an emergency in the eyes of the judge. Next, please. We're flying through this. So custody, you always hear probably that I want full custody, full custody. What does it mean, full custody? There's legal custody and there's physical custody. Legal custody is the custody that gives you a right and responsibility to make decisions about the child's health, education, and welfare. So it goes into which school my child will go to. It goes to, are they going to take therapy sessions? Are they going to wear braces? Am I pro-vaccine or against vaccine? Those are the major decisions about the child. If you have sole legal legal custody, you get to petition for the passport of this child. You get to agree to surgery, agree to therapy, agree to every other thing that this other parent who does not have legal custody can. Physical custody basically means who has the kids physically more. So physical custody means I have the kids majority of the time, or joint physical custody means we both share custody of the kids. So sometimes you'll have sole legal custody to one parent and joint physical. Sometimes they'll have joint legal and physical. Sometimes one parent has only sole legal and physical custody because the other parent did something wrong. For example, we're in a DV situation. Next. So once the parent starts a case with family courts asking for custody, regardless of how it's coming in, if it's coming in on the dissolution train, if it's coming in on the request for order, ex parte, even restraining order situation, the courts will either give you a note, call mediation and schedule your mediation appointment, or the court will order you to do that and sit with a qualified mediator and try to decide custody. Why is that super important? Because we've noticed after years of this, Contra Costa previously was a recommending county, which means parents would go sit with the mediator, didn't agree, and the mediator would draft a recommendation. After they've heard what they've heard, discussions with the parents, they will recommend what the custody order should be. Judge would typically stamp it into a court order. Nobody's happy. And we've noticed that if we actually make it a true mediation, meaning we allow those parents to sit down and craft a custody order that fits their family needs, meaning who works nights, who works afternoons, who can take kids to soccer, who can take them to ballet, who can do music classes, who is whatever. You know your schedule way better than a stranger in a robe. If you get to settle in mediation and make a custody order that as parents you know will work for you, this is a beautiful thing because you will be able to last on this custody order way longer than on the order that the judge, who doesn't know your family dynamic, doesn't know your schedule, will just randomly say, you do 2, 2, 3, and I don't care if you're working on Tuesdays, this will be your day, figure it out, right? So I always tell every case I consult with, and I know I'm working for a family justice center, I know we're working with domestic violence, I always recommend to settle, especially for custody. If you can figure it out how to make it work, that will work way better than some stranger telling me what to do. So everything that is discussed now in mediation is confidential. If there's no agreement, nobody will hear a beep about it. The judge will have no idea about what was discussed in mediation. They will review the file. If there's no proper explanation from either parent of what the issues are, if there's no declaration, they will rely on a very scattered testimony from both parents and try to figure out what to do, right? So always have your client respond to petitions, suggest good custody orders. If your client responds to the paternity petition or a request for order for custody with her own plan that she feels or he feels will work for the family, once the judge sees that plan and say, hey, this is reasonable, I can make that work, your client is better off than sending them without nothing. So either have a declaration filed with the courts, declaration goes on forms MC30, have the client explain what are the custody concerns, what are the health and safety issue concerns, why do this parent needs to have the kids more than the other, have this filed with the court, it becomes part of the file. The judges see about 100 cases a week. If your client comes back in 2 months, trust me, the judge will never remember what was said in the hearing. Very rarely we have hearings recorded or we have court reporters in the hearings. The AI is transcribing things, but the judge doesn't always have the chance to go back and read exactly what happened over the 20-minute hearing. So it's always best to have a declaration on file, explain what are the client's concerns, why they're asking for this custody order, and why they think this custody order is reasonable. If they manage to convince the judge in writing, you're way better off. That declaration stays part of the file. The next judge who takes this case two years later on their assignment will be able to read it and know, okay, I know what's going on. All right. So mediation, super important. Prepare your clients for mediation. Prepare them to come in with a schedule. Prepare them to offer something reasonable. They need to be able to figure out what will work for the family. If they're relying on the judge, 99% of cases, they're going to get something they don't like, because judge's job is not to make both parties happy. Quite the opposite, is to make both parties unhappy. If everybody's walking away with, well, all they wanted, that means the judge didn't do their job right. Okay, let's go on. Fee waivers. Well, I already discussed that briefly. We have two forms for fee waivers, FW001 and FW003. One of those forms, in the middle of the form, you'll notice that the questioner is asking if the client receives any state benefits, and those are like food stamps, medical, VIC, CAPI, unemployment, or some other ones. There's like a list of 8 or 10. If that's the case and your client is receiving medical, let's say, you check that box, the clerk at the window may be able to grant the fees, the fee waiver for the client at the time of filing. If the client is not receiving any of those state benefits, they will have to, on the second page, list their expenses and income. If their income is less than their expenses, a hearing will be scheduled with the court for the judge to examine if they can afford those fees. So we're talking about filing fees of, starting a divorce of paternity is $35, or now it's probably even a little more. And starting a request for order is $80. So if they can bear those fees, awesome. If they cannot, and they're not receiving any benefits, they will have a hearing scheduled with the judge to examine if they can truly afford it or not. Sometimes the court may conclude, okay, pay as an installment. So pay $50 a month for some time. So that's fee waivers. Let's move on. Oh, restraining orders. So restraining orders, it's basically an injunction. It's an adult timeout, I call it, and that's how I explain it to my clients. It's separating the parties by a football field, not allowing them to call each other in contact. Why we do this? We do this so the water can cool off and calm down. If the situation is very hot, we put the adults in timeout, the courts do, and we wait for them to calm down and start thinking straight. The restraining orders are a shield to protect the victim. They're not by any means a punishment for the perpetrator, but we need to always remember that a restraining order, in the end of the day, is just a piece of paper. It's not a shield, and it needs to be part of a very comprehensive safety plan. It's not a tool on its own that's going to save everybody and everybody's safe because there's a restraining order. It's just a piece of paper in the end of the day. Let's move on. So we have many different restraining orders available to us. EPO is an emergency protective order. You see that a lot. It's the restraining order that the police officer at the scene calls the judge in the middle of the night and tells the situation. The judge then decides, yeah, they need an EPO or they don't need an EPO. If there's an EPO granted, it's usually anywhere from 5 to 7 days, which would give this client enough time to go and seek other restraining orders. CPO is a criminal protective order. It's granted to victims of criminal cases in criminal court. The criminal judge decides if this victim needs it or not. Usually, domestic violence that is seen in criminal courts is the domestic violence that has some significant injury to the body. So a definition for each of those restraining orders is different. We're talking about one DV incident, and depending on which restraining order options we have, it may or may not qualify. So criminal is a CPO. It's called CPO. It's awarded up to 10 years. if the criminal protective order you receive from client says no contact with the client and her children, right? And this is something you need to remember. Criminal protective order is like this, the king of all orders. If the king says no contact, that means little guys like us in family court cannot do anything unless the king changes his mind and says, yes, we can allow contact. If the CPO says no contact, there will be no custody orders, no visitation. And the family court will block them with just showing of the CPO and that little box, I think it's number 12, being checked. If the box number 12 is checked, don't quote me on the number 12. If the box for no contact is checked, that means there will be no contact and family court cannot bypass it or decide otherwise. Civil harassment restraining orders. We see those a lot. You probably already know that you don't have to have a qualifying relationship for a civil harassment restraining orders. What I need you to remember is that it needs to be a pattern of abuse. It cannot be one single incident. If it's a one single incident with some forms of stalking or harassment after, sometimes the judges will deny that order and the client may be able to prove their case at the hearing. The problem with that is if you only have one incident and you file this restraining order and it gets denied, it still needs to be served on the opposing party, right? And they did something horrible and they get served with a restraining order that was denied. As a perpetrator, being served with such document, what would you think? Oh, nothing's going to happen. I can do whatever I want. There's no consequences. So a lot of times after this denied restraining order is being served, the opposing party will do something similar or something in the same genre. And then the client comes to court for their hearing and they need to start with, this person violated this restraining order by doing the following. A violation of a restraining order, temporary restraining order, is enough for a restraining order itself, right? So even if we file something on the very minimal evidence and it gets denied, but the courts still say he needs to stay away or she needs to stay away from you, if they don't, that will be your first argument. We also have elder abuse restraining orders. Those are restraining orders for clients over the age of 65 if the perpetrator is a close person, meaning a caregiver or a person who has access to their finances. This one covers a lot of things, including move away. Civil harassment restraining orders are not eviction tools, so you cannot evict anybody from a household. Let's say we have a roommate situation, right? And there's harassment and stalking. One roommate files a restraining order against the other, asking the court to kick the other roommate from the house. Wrong motion. We cannot do that in a civil harassment restraining order. If you were a couple, though, you could do that in a domestic violence restraining order, or you could do that in an elder abuse restraining order, provided you have the right to the property. If a survivor, there's a question, if a survivor comes to US with a restraining order issued in another country, how do courts here respond? You need to register that motion here, and it will be treated the same way as any other restraining order. How to distinguish between domestic violence versus criminal protective orders. Criminal protective orders are issued only by criminal court. We don't petition for them. There's no form to ask for a criminal protective order. This is the criminal judge's decision. The domestic violence restraining orders we petition for, we need to show up at the hearing, and we have a different burden. So one thing to remember, there's a way higher burden in criminal court than it is in family court. Burden of proof, meaning how much evidence do I need to put on this issue to tip the scale in my favor, right? So for criminal law is basically you need to show that there's no other way this happened than this way, right? There's like 51% of chances or even more. I have like I've proved it 70% of chances that there's no other way this happened other than the way I claim. In family law, it's more likely than not. So I will hear out your testimony, and decide who's more credible, who is telling the truth. More likely than that is a very low standard compared to the criminal system cases. How would they go about restraining that order, registering that order? In the county where the client resides, if there's a custody case following her, it depends, because if there's a custody case in some other jurisdiction, moving here, you may register the custody order with the family courts here, and the process is complicated, too much for this class. So you register that custody order, or you ask the court from the prior jurisdiction to relinquish their jurisdiction, meaning you no longer live here, nobody from this case lives here, you move to California, we're going to move this case to California. It's a very long process, so it really depends. If there's only a single restraining order, great. If it's from US, it should be with CLATS system, the police system. If it's not, there's ways to register to make it enforceable here. If you also need to move your divorce or custody, that's a whole different story and a longer conversation than this class today. Next, please. So how does the restraining order process works? Family Justice Center has they're gone now, had very amazing interns who drafted restraining orders for us over the summer. Actually, we're looking for interns, so if anybody's interested in interning with us and learning how to draft restraining orders, please reach out. You basically file the declaration, file the documents. It's also forms online. We file them online. You need to have a lot of forms. So you start with the mandatory 3 forms, which is DV 100. That's the main driving petition for the restraining order. You need DV 110, DV 109. If you're asking for child custody and child support, you need DV 105 and 140. If there's issues with abduction, worry that the child may be abducted, then you add more forms to it. Again, needs to be served by the sheriff. The documents, let's move on. Oh, I have a definition, legal definition here. Why is it not showing? It's a secret. So domestic violence, and I need to tell you the legal definition because a lot of times people go one spectrum or the other. Some people tend to think there's no domestic violence if there's no physical injury to the body. Some people tend to think that you need a restraining order because there's verbal abuse. So if you could show this, the full slide. So domestic violence legal definition is a pattern of coercive behavior. It's pattern. It's not a single situation. We don't run to court because we had an argument, basically. Not every argument needs to end up in court. Actually, the opposite. Most of them should never go to court. So it's a coercive behavior, not limited to actual infliction of injury or emotional distress. So we don't really have to have physical bruises to ask for domestic violence restraining order, but we need to show a pattern of behavior that expresses power and control over the other party, right? We need to have an intimate relationship, which means you cannot file a DVRO against your neighbor. You need to have some type of closer relationship. I will get to that in a second. So it's intimidating, threatening, harmful, or harassing behavior. Next one. And for DVR, what about if restrained party has firearms? Is there a court document that enforces? Firearms is you can upload the whole thing. So firearms is a completely different situation. The person served with the restraining orders is required to go to a police station or a licensed gun dealer and relinquish their weapons at the like shortly after service. They need to show up at the first hearing with the form DV-800 showing that I did relinquish my weapons to the police officers, okay? We've had issues with the relinquishments in the past. I believe the courts are doing way better. I've had few hearings in which the restraining order has been resolved, and then there's an issue of guns, which should have been addressed at the first hearing. It's usually addressed at the end of the case. The court will have a special hearing to discuss if, first of all, are there guns in this case? Have you seen those guns? Have you relinquished those guns? Are your documents legit? Right? So yes, there is a requirement to relinquish your guns. So what is interpersonal violence? It's child abuse, human trafficking, elder abuse, stalking, domestic violence, and sexual assault. There's layers and layers and layers to it. So I know you guys see a lot of different cases. You probably understand it as well as I do. So let's move on. We have about 30 minutes to go. And I know you guys will have questions. So the family code section definition of abuse is intentionally or recklessly cause of bodily injury. And why is that first? Because if you're drafting a restraining order and there's no physical violence, there's only verbal, emotional abuse, and maybe some financial or maybe religious, that restraining order generally is not going to be granted. So if you have a case with physical violence, always start with physical violence first. That's the argument that tips the scale and makes the judge say, okay, I'll grant this temporary restraining order. Okay. So if you have a case with no physical violence, really look at the facts if you have enough for a restraining order. All right. So intentionally or recklessly causing bodily injury, sexual assault, to place a person in reasonable apprehension of imminent serious bodily injury. So let's say driving somebody to the cliff and asking them to stand in front of the car. Or I can give you many examples, but it's not my goal to traumatize you this morning. It's Friday. So let's move on. Unless there's questions. Is it interesting to see the framing of the definition? Because when I see a court order for anger management classes, there seems to be disconnect between the legal definition of, oh yes, 100%. But we'll get to it. We'll get to it with my favorite definition of, because there's more definitions coming. I'm just giving you a little overview. Let's skim on the top, on the surface of the definitions of DV. So what DV includes is molesting, attacking, striking, battering, sexually assaulting, stalking, coming within a specific distance, and harassing, threatening, contacting directly or indirectly, telephoning, harassing phone calls, destroying personal property. Next. I believe the next one is my disturbing the peace of another. Okay, so this is the catch-all definition of DV, right? So conduct that based on the totality of circumstances destroys mental, emotional calm of another person. It may be directly or indirectly done by this party or a third party, by electronic means. This conduct may include coercive control, forcing somebody to do something, or causing emotional disturbance for no reason at all. It's a pattern of behavior that has no effect, unreasonably interferes with person's free will and personal liberty, and may include isolating the other party from friends, relatives, and other support, child abuse. I'll give you a good example of something I was very successful getting a restraining order based on disturbing the peace. It was a case of a wife who every day coming home was stressed out that her husband is trying to commit suicide. So every day he would come up with different ways to do it. I don't know if it was attention seeking or he was in fact very disturbed. And she was just tired of it. She was like, I cannot go home. I don't know what to expect. We argued that this behavior is disturbing her peace, and we prevailed. So it could be any behavior, but you need to be able to show a pattern of abuse and that this behavior is done with malicious intent, right? So a lot of things will go into a definition of domestic violence. A lot of things are qualified as domestic violence, but still the client is not getting a restraining order, and we're confused to why, because yeah, it's definition and da-da-da-da. Well, not every level of domestic violence qualifies for a restraining order. People argue and they call each other names when they argue all the time. We did that in kindergarten. You stink. No, you stink. So this is the same version, but with adults, right? So just because we argue and call each other names is not a reason we need to restrain each other, be restrained, and ask the court's involvement, right? So, well, yes, husband is not giving me enough money. That's financial abuse. Yes, it is financial abuse, but the way courts resolve this financial abuse is by separating parties and ordering child support that this other party is refusing to pay. So it's not something that will make your case better. Just because there's DV doesn't mean we need to run and ask for a restraining order. Quite the opposite. We really need to make sure that there's safety concerns. This client really needs this restraining order, and we're not running to court on the restraining order train because they had one altercation and now the client wants full legal and physical custody of the kids. Okay, that is not the case ripe for a restraining order. If that's the case, they're breaking up, they had few arguments, the client never indicates their safety concerns, there's only custody issues, send her to file a paternity action, resolve custody, and maybe there's no need for a restraining order. Next, please. Cycle of violence, the spiral of violence. I'm not sure how much time I need to spend on this. You guys probably already know it. It's a spiral that goes from a blow up, then there's a honeymoon period. I'm sorry, this will never happen again. Flowers, gifts, and then there's a tension building situation in which the victim walks on eggshells. They know, they feel it, they smell it. There's a smell to it. I don't know. The clients sometimes say there's like they can smell there's something coming, and it's just a matter of days when we're gonna have another blow up. That's the eggshell situation, and then another blow up. On average, it takes a victim of domestic violence to leave the relationship. She needs about 7 tries. So that is a statistic, but if you think about it very closely, the 7 tries may happen over a span of 5 years, but it may happen over a span of 30 years, right? So those are 2 different types of clients because they've had way longer to deal with this issue. Next, please. Domestic violence restraining orders are like mini divorces, and that's why we like them so much, and that's why we choose this process as the first process in the case. I compare starting a case with a restraining order like starting a case with a bucket of vinegar on somebody's head. If really there's no major safety concerns or issue, there's no violence, like physical violence, sometimes it's more beneficial to start a regular divorce or just a custody case and lean toward mediation settlement than fight it out in court. Statistically, cases who end up in court last way, way longer, meaning they litigate the case way longer than cases that settle. If you can settle, you're getting somehow what you wanted, but it's going to work and last way longer. The expiration date on those settlements is way longer. The shelf life of settlements is longer than the court's order because you're getting something you don't like, you're going back, something's going on, the kids are unhappy. I'm going to ask the court to move on. So with a restraining order, we get to almost do everything as we do in the divorce, meaning we can ask for move away orders. We can ask for exclusive use and possession of the family home if we have the right to it, meaning we're on the deed or lease, or we've lived there for 10 years and it's part of community property. We can ask for spousal support and child support, custody orders, pay debts associated with abuse, pay bills, rent, utilities, keep me back on my insurance, disconnect cell phones, control property, attorney's fees, gun restrictions, cell phone. You can disconnect your cell phone with the restraining order and no longer be on the family plan. Permission to record conversations. So there's a lot of things we can accomplish within our DVRR process, except for the actual divorce. So we can say victim stays in the house, the community home temporarily, the perpetrator pays spousal support, child support, we have custody orders. So they're kind of settled for the time being, and then they get to go back and resolve the rest of their divorce situation and get the judgment. Next, please. So who will qualify to this amazing tool called a DVRO, restraining order? It will be a victim of abuse who is in the following relationship: spouse, former spouse, registered partner, cohabitant, must be more than just roommates, right? So it will be like more of a couple type of deal relationship, dating or engagement, had a child together, personally related by blood or marriage within a second degree. So we're talking about parents, step-parents, parents-in-law, siblings, child spouse, adopted child, grandparent, grandparent-in-law, step grandparent. So there's a long list of people who will qualify. Definitely your roommate is not going to qualify, your coworker is not going to qualify, your neighbor is not going to qualify. It needs to be a close, keen relationship. Next, please. So what is a dating relationship? In the current era, we will encounter cases in which they met once, but they've been talking online for 3 months. Is that a relationship? Can we say they've dated? They saw each other once, right? The legislator came with a definition. What is a dating relationship? It's a frequent, intimate association, primarily characterized by expectation of affection or sexual involvement, independent on financial considerations, right? So OnlyFans person you hang out with or ChatGPT, there's no relationship, right? If you're paying for conversation online, that is not a relationship. But if you're online dating and having long conversations with that person and you have the expectation of intimacy, yes, I would go with the DVRO, unless the client is not sure themselves and they're worried that the other party will come and challenge the relationship and say, no, we've never dated. This is the wrong motion. We should be here on the civil harassment restraining order, not the DVRO. There's higher burden for the civil harassment restraining orders than there is for DVRO. So we always choose the DVRO. So what do you guys think? Is one date enough? I don't know. Next, please. So this one gives you a snap of what we're looking for a DV situation. So controlling, regulating, blocking movements, all that. But as I said, if the client comes over and says verbal abuse, emotional abuse, she didn't let me or he didn't let me see friends, and I had no money to buy lunch, probably not, or 99% chances are they should not be filing for a restraining order. But if there's like stalking and there's physical violence and there's major, I don't want to say major, I'm not distinguishing between the two, but not every aspect of DV requires a restraining order. I'll end at that. Next, please. So the process, I already briefly told you about this. We filed, the client comes to pick it up the next day. We can move to the next one, please. The court issues a temporary restraining order. That's the previous one. The court issues their decision the next day. Client comes back to pick it up. And here's a little roadmap you see. So we requesting one, the court is granting or denying the TRO within 24 hours. Then the client walks it to the sheriff's office. DVROs are served for free by the sheriff, by the way. Not always the best option because the sheriff's office generally has other things to do than serve documents on restraining orders. So it's not always the most efficient, which we totally understand. If the client has another option to serve the documents, let's use that. So once the service is completed, the proof of service needs to be filed with the courts. Then there's a hearing. At the first hearing, the opposing party can ask for a continuance as a matter of right. They want to get an attorney, read it over, they need more time, whatever the reason is, they're going to get it. And then we are stuck into another continuance, right? And then something that people don't usually understand, and a lot of times I feel like I'm making the clients angry when I say this, and the following is true. They show up at that hearing, it's going to be a 20-minute hearing. It's a short cause hearing. The court will have only 20 minutes for this case. So the first 5 will be taken by administrative discussions. Was there a proof of service? Then the client will have about 5 to 6 minutes to state their case. They're not going to be able to do that. Then there's another 6 minutes to the opposing party. Let's move it to another date. So in a way, the client will have about 5 to 6 hearings every month, right? So for 5 to 6 months, every month, they have to show up in court for this short little 20-minute hearing, trying to prove their case. The court may offer, and that depends on how complicated the case is. If it seems a little bit more complicated for the judge, they'll say, let's continue your restraining order to a few months ahead, and I'll give you a bigger chunk of time called trial, like a long cause trial, where you can all present your evidence. So for that, in those situations, the client's temporary restraining order is extended to the trial date. They wait. In the meantime, the court will address the custody situations. They'll go to mediation. We're trying to figure out custody. And then a few months later, sometimes it depends on the county and the judge. Some judges will give me a trial the same month, and some judges will make me wait a year. Some judges will make me wait 6 months. So it really depends on the county and the judge and the weather and the solar system. I don't know. So sometimes they'll wait for 6 months to have a resolution. During that time, maybe the situation is calming down, they don't need it. If they don't need the trial, they can always stipulate and drop the date or drop the restraining order. So the clients should be prepared that it's not a quick process. And when we say 27 days later, you're going to get a hearing, it does not mean you're going to get a resolution within 27 days. It will mean you're going to get a first continuance in this case on the first day of your hearing. Okay? Because probably 80% of those cases, the first hearing, it's a continuance because somebody's not ready or they want an attorney or they need to, I don't know, do it. Next, please. So we need to serve the other party at least, and the requirements for personal service is the same as with divorce. Here, it needs to be done at least 5 days before the hearing. Preferably, it's 7 days before the hearing. The proof of service always has to be filed. The judge will not even look at the client or discuss the merits of the case unless the other party got notice. Next, because I will run out of time with questions, and there's more slides. I already did through the hearing. One thing that I forgot to tell you guys, if there's proper proof of service and the other party doesn't show up, that means the client wins. The restraining order is granted, no further hearings. So if we do have the proper proof of service and the other party just decides, I don't want to participate, I don't care, get a restraining order, that client is getting a restraining order, no bueno, done. She doesn't have to go back or he doesn't have to go back. Next one. Mutual restraining orders. Oh, one thing I forgot to tell you, if our client doesn't show up at the first hearing, that means the request is dropped, right? So it's essential that the petitioner is there. If the respondent was properly served and doesn't show up, then the petitioner wins. But if the petitioner is not showing up, it's dropped. So we see a lot of mutual restraining orders, and I feel like we're not having a full understanding of what that means. A lot of times we'll see a client who was served with a restraining order, and they come to us and say, no, this is not what happened. It happened completely 180 degrees the other way. I'm the victim here. He broke the door. I was hiding behind the door. Or let's say the victim says, well, yeah, sure, this happened, but he did A, B, C, D, E, and G, or she did A, B, C, and G. So in that situation, we will try to level the playing field, especially if there's kids. Why we do this? Because if one parent has allegations of DV and they prevail and obtain a permanent restraining order after the hearing, there's this beautiful piece of legislation, and we use it all the time. It's Family Code Section 3044. I haven't made a slide for you, but write it down. Remember 3044. It's the law that provides the victim of DV parent full legal and physical custody of the children once a permanent restraining order is granted. What that means is we're not taking away custody from the other parent. We're giving them visitation up to 40%. So technically, you cannot have a 50-50 custody order if there's a restraining order protecting one parent, unless the perpetrator parent rebutted the 3044. So let's say in the restraining order, the court ordered the respondent parent to do parenting classes, better intervention program, and therapy, right? And there's this presumption kicking in. The Family Code Section 3044 is in. The victim parent receives full legal and physical custody. The respondent parent wants to have more time with the kids. After the restraining order expires and they've done their homework, they may go back to court and try to rebut the presumption coming from the restraining order. Is that clear? Next, please. Oh, well, we can go back there for a second. I forgot to tell you one thing. So in a mutual restraining order case, let's say one party has 4 allegations of abuse and the other party has 4 allegations of abuse, and sometimes they can be the same, right? Every incident of abuse alleged, the judge will examine who was the primary aggressor and who acted in self-defense, right? So you may have different resolutions here depending on evidence. Let's say your client is more successful and the other client is not successful in proving their case, the court will grant restraining order to your client, deny the other parents. Sometimes the court may decide, hey, on those 2 incidents, the petitioner was the primary aggressor, but on 2 other incidents, the respondent was primary aggressor, mutual restraining order. In those situations, there's no primary victim parent. Family Code Section 34 does not apply, and we're backed into the best interest of the children standard. The court will examine who will be the parent acting in the best interest of the kids. Next one. How many slides do we have left? So I'm sure we finish. Renewal of the restraining order, I'll just say it very quickly. It needs to be done 90 days before the expiration of the restraining order. I think we're pretty close to the end. It needs to be done 90 days before the expiration of the restraining order. Please always tell your clients to be watchful for that. Don't let them lapse. Getting a new restraining order with old facts, very challenging. That requires another trial. That requires another dance in court for months before it happens. So if it's a really situation in which the client requires the restraining order for safety, don't let it lapse, please. The standard here is not necessarily violations of the restraining order, but a reasonable fear of future abuse. So that's a pretty low standard. Your client needs to show that I'm still scared. Like, those are the reasons why I'm scared. The court will examine the prior restraining order, what was proven in the prior restraining order. Was there any violations? There doesn't need to be any violations for this restraining order to be renewed, as long as the client can show that they have this reasonable fear. It may be extended for up to 5 years. Burden of proof, preponderance of evidence. Next one. Well, this is something to be cautious and keep it in the back of your mind. Sometimes we see very awful cases and we want to help the client, and we feel like if we spill out the truth on the forms and then the declaration, it's going to make their case stronger. And that's all true. It's all true, and it's all necessary to do a good job to have those restraining order granted. But on the other hand, keep in the back of your head that it's public record. That if we put a lot of very intimate details there, the nosy neighbors, the girlfriends you probably heard of or have yourself are very nosy. They go to the records office, they copy it, and they have all the dirt that is going on next door, right? Oh, you have the kids 20 years later go back to the records office to figure out, why did mommy and daddy break up? And they read it, and it's shocking. So I'm not saying don't put things in, but be mindful of, at some point somebody will go, and let's not put things that will be very embarrassing for this client. A person 12 years of older may ask for a DVRO. In some of those cases, the court will ask for a guardian to help them, or if there's no attorney, we'll ask for like a parent figure or something. always make sure you have the requiring relationship for the DVRO. If you cannot check any of the boxes on the form DV100 for the relationship, that means you're on the wrong form. Go to CHRO 100. The forms are the same numbers, it's just the letters are changing. So it's DV 100, it's CH 100 for civil harassment. So there's no requirement to provide an address, although, and you can get a restraining order without providing an address for the courts. In some situations, there's a new clerk sometimes and they'll bounce the restraining order because there's no address. There's no need to provide an address. They can make it confidential. And if that's the case, you can just say confidential, provide the city for the address. You can ask for some information to become private to protect the child. Next. That's it. Questions? Will the slides? Yes, they will be available. Jose can send them to you today. If you find any misspells or grammar mistakes, you're free to correct. I've been preparing those this week and last week, and I had trials, so they may not be perfect, but they should give you good enough information to be able to start the petition or paternity for your client. So this is great presentation. Can you lose your permanent resident after divorce? Well, you can move wherever you want to. So once your divorce is finalized, you're not stuck with the courts, right? So sometimes people even move during the process. You finalize it, you have a judgment, and you're done. Any other questions? Resources would you rent to help folks start a divorce? Well, I'm not sure if there's still an option to file your own DVRO on a court's website. Last time I've heard they're working on it. There should be a platform with the Contra Costa courts allowing clients to start many cases online just on the court's website. So there's more changes coming in that department. California is designed for people without an attorney to be able to do everything. So every form has law embedded in them, and it's a roadmap. If you're doing custody, the form will tell you. If you're asking for custody, now go to this form, and this form will tell you now go to. So it's a complete roadmap that will lead you from one to another. Even judgments, we're not allowed to even do our own typed up judgments. We need to use the forms because the forms have the law embedded, so you cannot go wrong using the forms. Is that an immigration question about the permanent residence after divorce? If it's truly an immigration question here and the permanent residency was granted through the marriage, that's a whole new conversation. Well, it's going to take me a few minutes to respond to it. So if your marriage was done conditionally, there needs to be a condition. Our experience has been that it is easier to petition who are survivors to obtain DVRO. Yes, CHRO has a higher denial rate because, as I said, people think that one argument with a neighbor is a reason to file for a restraining order. Hell no. We need a pattern of abuse. This neighbor needs to actively ruin your life almost daily for this to qualify. And one argument is not enough to file for a restraining order. Moreover, like the courts want to see people figure it out, not just run and say, oh, they need to stay away 100 yards from me because they wanted me to push trash in another place. Like, no. So yes, CHROs are denied more often. And as I've mentioned, the burden to prove, the amount of evidence you need to lay on a CHRO case is higher than you need to lay for the DVRO. So it's easier to get a restraining order in family court because the presumption is way less. It's like, who's telling the truth, basically. How about your neighbor double parked all the time and they said they don't care about the law? Don't file a restraining order, okay? parking violations, the courts don't care. It's not harassment. Just because somebody's annoying, it doesn't mean you can call it harassment. It really needs to, I wish I've put a harassment definition for you guys. It needs to raise to a certain level of annoyance. Just because somebody's like nuisance is not something you should be filing a restraining order for. Let's say you move into a neighborhood and there's a basketball court next to your house. You cannot file a restraining order against those neighborhood kids playing basketball and causing nuisance. Like, nuisance is not a reason to file for a CHRO. Just because somebody's annoying doesn't mean they need a restraining order. Okay, what is this? Who believes?
Magda, we also have one hand raised by Leslie. Once you wrap up with that question.
Yeah, amended that the respondent remove a video from their personal smartphone, a video that contains the respondent and the petitioner engaged in unwanted sexual, and wants the respondent to promise not to keep it. So this is a case, there's a probably sex, I don't know if I'm getting this right. There's a sex tape between the parties, and one is trying to prevent the other from sharing that video. Is there a valid threat, right? Somebody's fear also needs to be reasonable. Is there reasonable fear this video will be used? Was there a threat this video will be used? Do you have a proof of this, right? If somebody's actively telling you, if you don't do X, Y, and Z, I'll post the video, maybe you can build a case, but that alone, not enough. Leslie?
Hi. It's a it's a mix of family and immigration question. I wanted to know if the I-864, the affidavit of support that petitioners file, can that be used in family court to push for longer spousal support because it's a federal contract?
Very good question. Very, very good question. Yes, because the affidavit of support is a contract. You have a very good understanding of this. It's a contract between the sponsor spouse and the US government. And in that contract, the sponsor spouse says, I will not allow this alien, because now we're bringing aliens from other countries, I will not allow this alien to become public charge. Public charge means I will not allow them to go and draw unemployment or other benefits reserved for residents or citizens.
Yeah.
So yes, if now this spouse is asking to have a seek work order against this alien spouse, the alien spouse can just simply say, Your Honor, I have this document here he signed with the US government. Until I obtain my citizenship, I'm under his umbrella. It is not the strongest argument under the planet, but yes, it's a good one. It will buy some time. But at some point the court will say, honey, you've had this permanent residency for 10 years. It's time to get the citizenship done. Like, they're not going to drag it forever. At least I wouldn't, because it's unreasonable, right? Any other questions?
Got it. Thank you.
You're welcome. No más?
I just want to confirm that when you're serving papers, then it's not, I have a client that believes that if you don't sign it, then you're not being served, and that's not correct, right? They can literally just say you're being served and drop the papers in front of them and they've been served.
Correct. And they don't have to read them. I've had cases in which, like, I never took the documents. Well, that's your fault.
Okay. And then the second one, just to confirm again, that I heard all the very difficult things about getting a restraining order, but in reality, if I know there's exceptions, but if there's not any proven physical DV, it's just maybe an incident happened once, very difficult to get a restraining order.
Very difficult, unless you can really lay out a pattern of abuse.
Got it. Thank you so much.
And that would be like, I cannot go to Safeway. I don't have a phone. I don't have a card. I cannot get employment. I'm like stuck at home all the time. I had to ask a neighbor to get me to Family Justice Center to get some help for a restraining order. Like, it really depends on facts of the case. you will have a feeling it's like, okay, I know there's no physical violence, but there's a lot going on. It will be a long declaration, but it needs to be laid out that it's a pattern of abuse that is trying to assert control and dominate this person.
Okay, thank you so much. Great information.
Any other questions? I love questions. Please ask questions. Well, if there's no questions, happy Friday, everyone. This was a pleasure. I love to talk for 90 minutes and listen to my own voice. I hope you all have a really good weekend, and I really hope this was helpful. Oh, there's one. I have a client who needs legal advice with her custody case. Can Family Justice Center help, and how can they help? Well, the process is such your client needs to find herself a navigator, not find herself, call us and be assigned to a navigator. And that navigator will be able to find one of our attorneys under a rock hiding somewhere next to a river, and we'll take a call. Are there any organizations that support the divorce process at no cost? Yes, Family Justice Center, Bay Area Legal. There's actually, in fact, a lot of legal document prep places that will facilitate the preparation of the documents for low cost. I believe they charge like a few $100s for it, which is a deal compared to attorney work. Honestly, filing a divorce takes us around 20 minutes. Attorneys charge a lot for that. It's not worth more than like $100 or $200 payment. So there's a lot of different document prep places that are pretty decent, and they also can use the court's facilitators for free. So there's every court has a facilitator's office. They advise and check documents for free. They speak many languages, so that would be probably the resource I would use most. If they're looking to hire an attorney, Contra Costa Moderate Means Bar Association program is phenomenal. They connect clients with attorneys who are starting family law, but they know enough to practice, but they charge lesser fees. So depending on their income, they may be charging, I think it's anywhere from 80 to 150 an hour compared to double or triple that amount on the market. So that's a good resource to remember. Moderate Means program with Contra Costa Bar Association. Where is your address in San Francisco? I don't know. I'm not in San Francisco. We are in Concord, Antioch, Pittsburgh, no, Antioch, Danville, Richmond, and Solano County. So I'm sitting right now in Concord office next to Jose. He's next door. Any other questions? All right. Happy Friday, everyone. I hope this was helpful, and see you next time.
If there's any other questions, I made sure to send you all out the invitation. Please send them over to Jose. I can connect them with Magda. I'll go ahead and place into the chat how to find a family justice center in your local area. Additionally, there's going to be a survey that's going to be going out, so please take a few minutes to answer that. And I'll also be sending out the PowerPoint presentation in addition to a link for the video. Thank you so much, everybody. Have a great Happy Friday.
Thank you, Jose.
Thank you so much.
Thank you.
Bye.